might sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Stop shutting my mic off, please.
Your Honor,
Why are they shutting my mic off?
because he's talking.
I'm the federal witness of the United States federal government. I demand some respect, you. All I did was trespass on property.
Ma'am, you got to create the community that you want to live in.
Anthony Johnson. Yes, ma'am. In your case, sir, you were picked up for violation of a condition of pretrial release, and bond will be set to 0, no bond. And I am appointing a public defender to represent you. Charles Michael Harrison. All right. Mr. Harrison? Yeah. You were picked up for trespass on property after a warning, and bond will stay set at $500 as to that.
I'm sorry, Your Honor. The offer from the state was an adjudication of guilt, 10 days in the Orange County Jail with credit for 2, and no return. You have the address?
To Advent Health Orlando, 601 East Rollins Street, absent medical emergency.
You would like to accept it as a plea of no contest?
Yes, ma'am. May I have the plea form?
Yes, Your Honor. Oh,
Mr. Harrison, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read the plea form before you signed it?
Can't see without glasses.
And did the lawyer read it for you or go over it with you?
Not yet,
See the lawyer? Did she go over it with you?
I guess.
Okay, look at the lady standing beside you. Did you meet her earlier and did she go over the plea form with you?
She told me some stuff through the window.
Oh, through the window.
He was in the cell, so I had to speak through the.
Okay.
Your Honor.
Well, would you like to have more time to read this plea form?
I can't see without glasses.
Would you like for her, or someone to read it to you first?
If you want to.
Well, I kind of have to, sir. I can't take your plea without being sure that you've read this. So I'm going to read it to you.
That'll be fine.
All right. You going to listen while I read?
Yes, ma'am.
Okay. And why can't I read your handwriting this time, Miss? It's 15 days in jail?
10 days.
Oh, 10 days in jail. Got it. And how much time served again?
Yes, 2.
2. All right, Mr. Harrison, now please listen carefully while I read the plea form to you, okay?
All right.
And this is a plea form for a plea of guilty or no contest for a criminal charge. And of course, your charge is trespass on property after a warning. And the offer is 10 days in jail with credit for 2 times served.
What do you mean warning? This was 2 different places. This
Well-
was Advent Health and 7-Eleven.
He pled to the 7-Eleven trespass a few days ago, Your Honor.
Yeah.
All right, you already resolved the 7-Eleven case, and this case is the Advent Health trespass case.
Right, Advent Health.
Do you still want to enter the plea on the case for the property of at Advent Health?
Yes, ma'am.
Okay. These are the rights I need you to understand. I need you to understand the nature of the charge, the difference between a plea of guilty, no contest, and not guilty, the effect of each plea.
I pled no contest.
I understand. The right to a trial before a judge or jury.
I wanted to come here.
Okay. and that you have the right to an attorney and the right to have an attorney appointed.
Oh, did you know I'm in the wrong court?
No, you're in the right place right now. The right to have,
I'm in another building with a lawyer that we paid for, $5,000.
well, this is the lawyer that's representing you today. And I'm gonna read just a little bit more of this plea form, be sure you understand it, okay?
All right.
And you have the right to have her as your attorney, and she has been appointed to represent you because I found that you cannot afford one. You have the right to know if the judge is considering a jail sentence on this charge, and I am, 10 days in jail. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, ma'am.
The right to confront and cross-examine the witnesses and evidence at a trial. You understand that?
Yes, ma'am.
You have the right to call witnesses of your own at trial and have those witnesses subpoenaed by the court.
I don't want to go to trial.
I understand, I just have to be sure you read this, and since you can't read without glasses, I'm reading it to you.
All right.
You have the right to have a court reporter make a complete record of the court proceedings, the right to appeal any harmful error to a higher court, and to know the maximum and minimum sentences for the charge. Additionally, you understand and agree that if you are unrepresented by an attorney, you waive your right to consult with an attorney. However, you do have an attorney, she's standing right there beside you. And I did appoint her earlier to represent you. Are you under the influence of any alcohol, drugs, or medicine at this time?
No, ma'am.
Okay. And are you entering your plea freely and voluntarily without any threats or promises being made to you?
Yes, ma'am.
You understand you have 30 days to file a written appeal of the judgment and sentence imposed by the court. You understand that?
Yes, ma'am.
And if you don't have an attorney for an appeal, you have a right to have the public defender appointed for the appeal. By entering a plea of guilty or no contest here today, you understand that you may be subjected to greater penalties if you're ever convicted again, and especially if the current offense is a traffic offense, you could be declared a habitual traffic offender, but this is not a traffic offense. You understand that?
Okay.
If you are not a U.S. citizen, you understand that as a result of entering a plea of guilty or no contest here today, you will be subjected to deportation proceedings. You understand that?
Deportation to where?
Well, if you are not a U.S. citizen, you would be,
I'm a U.S. citizen.
okay, the deportation would be back to your country where you
I
originally.
was born in Birmingham, Alabama.
Okay, well, do you understand that, though? If you
Yes, ma'am.
were, okay. And if you are on probation in another case, by entering a plea of guilty or no contest in this case, the current plea will be used to prove a violation of probation against you. You understand that?
Yes, ma'am.
And by entering the plea of guilty or no contest prior to trial, you are giving up your opportunity to challenge the admissibility of any evidence against you and any opportunity to have the case dismissed. You understand that?
Yes, ma'am.
And if the charge to which you are pleading is a sexually violent or sexually motivated offense, or if you have been previously convicted of such an offense, your plea may subject you to involuntary civil commitment as a sexually violent predator upon the completion of your sentence. Do you understand that?
Yes, ma'am.
All right, now, I have read to you the complete terms of the plea form, and you did sign this, and or do you still want to have signed this, sir?
Yes, ma'am.
And you still want to go forward with your plea now that I've read to you the entire plea form?
Yes, ma'am.
All right. I find that there is a sufficient factual basis. I find that you are alert and you are intelligent. And I will adjudicate you guilty, order 10 days in jail. You'll be given credit for 2 days' time served. And I'll order mandatory court costs to be paid within 180 days of your release. I am ordering you to not return to the Advent Health. What's the address, Madam Prosecutor?
601 East Rollins Street.
At 601 East Rollins Street, Orlando or Winter Park?
I can double check, Your Honor, I believe it's.
Okay, just don't return to that Advent help unless you have a personal medical reason to go there.
I was there for sunburn.
For what?
Sunburn.
Okay, well, you can go there if you have a medical reason to go. As long as it's your personal medical reason, then you can
They
go.
discharged me anyway.
Well,
And
I'm,
room and everything.
okay, well, after today, you can go if you have a personal medical reason, but not if you, and don't go if you don't have a personal medical reason, okay?
I was taken there by a crisis unit in Lakeside.
Wow, well, I don't know what happened, but you said you wanted to enter this plea, so I went ahead and took it.
Okay, that's good.
Okay, you have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. You can exit.
Your Honor, just for the record, it would be Orlando, not Winter Park.
Orlando. Is Mr. Rodriguez's case? Jose Enrique Poltroncoso?
Good afternoon, Your Honor.
Good afternoon.
Judge, thank you for your courtesy. I understand Mr. Poltroncoso
Yes,
is out on a medical
I
outside of the
see.
building.
Okay.
I did file a notice of appearance on his behalf earlier this morning, and I would like to ask the court to consider finding a no probable cause with respect to the suspended license charge. I have pulled up his driving record at the Florida DMV.
I'll grant that if the state wants, unless the state wants additional time.
Your Honor, may I approach?
Yes, ma'am.
I pulled it up as well.
Mm-hmm.
At 12:30.
Mm-hmm.
I believe the reason he wanted is because he said he had a hardship. However, upon my reading, I don't see it. However, I'll leave it within your Honor's discretion whether or not.
There's nothing included in the probable cause affidavit to support this. The driver's license check, as of November 4th, shows that his license is currently canceled, suspended, revoked, disqualified, or withdrawn. I could consider this as additional information from the state and find probable cause.
Judge, if I could offer also, I have the website pulled up here on DMV. And while it does say as of November 4th at 12:33 p.m.,
Yeah.
it's suspended, it also shows that he has a business purposes restriction on it. I can show you the what I'm looking at if it helps.
Yes,
May I approach, Your Honor?
yeah, you gotta show it to her too. I mean, matter of fact, show it to her first. Sure. Then if she has no objection, then I don't need to see it.
Your Honor, I'll leave it within your discretion. State's not too concerned about.
Okay, I'm gonna grant that motion.
Thank you, Judge. Just you know, to make you feel better, there was a case, Orange County case in 2018. It's 18 MM 000595.
Yeah.
The reason it's relevant is because in March 1st of this year, that case found that there was a wrong date of birth on his driver's license. So they cleared a suspension and reinstated it. There was a subsequent case, or actually there's a prior case, 2017 CT 008940, also Orange County. It was a suspended license charge, but that license was reinstated in May of this year, May 25th. The D6 was cleared. And also in the most recent case prior to this, which is 21 CF 000107, the D6 was cleared on March 10th of this year. So all I'm saying is they've been working actively this year to keep his license valid. He has a hardship license, and so I believe that the stop was based on that, based on the police report here.
Well, absolutely, I did not see probable cause in the charging affidavit for the driving on a suspended license charge, so I granted your motion.
Thank you for
I'll
your
release them
courtesy.
on recognizance as to that charge.
Judge, the other two charges pursuant to this police report, right around the middle of it, it says, basically, they saw him in one location. They then followed him because they believed his license was suspended. As he was about to walk into an apartment, they arrested him. And so in the middle, it says, I approached the vehicle to turn off the engine and conducted an inventory search of the vehicle based on him being arrested for driving on a suspended license. My argument is that he was.
You're gonna have to reserve that argument because I'm finding probable cause for the trafficking in fentanyl.
Okay,
If you want to proffer, you can, but I am finding probable cause.
sure,
And
sure.
I also am finding probable cause for the possession of ammunition by a convicted felon. I am, obviously, it's without prejudice to you filing a motion and arguing your case law and legal basis at a motion to suppress hearing.
Yes, ma'am.
But my basis for finding probable cause is that the standard is significantly lowered. And I am going to find probable cause for that lower standard.
I understand. And
But I will allow you to proffer, obviously, if you prefer to do so. Otherwise, we'll just save it for the motion to suppress.
yeah, very briefly, Judge, I would only proffer that because it was a bad arrest
Go ahead.
and the subsequent search. But I would like the court to take that into consideration in determining a bond amount.
Okay. What says the state?
Your Honor, the arguments the counsel is making are affirmative defenses, which would only be relevant if this was filed. And it hasn't been determined that it was a bad stop. I think more information needs to come out regarding this business purposes only.
I didn't say it was a bad stop. I just said I didn't find probable cause.
Understood, Your Honor. He's just making the argument that the bond should be lower due to it possibly being a bad stop.
Okay.
I'm just putting on record that that has not been determined at this
You
time.
do understand that if there was, that my finding of probable cause is only a finding as to the release conditions and whether I'm setting a bond.
Yes, Judge.
It has nothing to do with whether I find the stop was bad, good, or indifferent.
Yes, Judge.
All right, so everybody understand that.
Yes, ma'am.
That's why I am going to find probable cause for the trafficking in fentanyl. I have no idea all of the other things that those officers were seeing, hearing, experiencing when they stopped that car that maybe they are able to provide to the state. I find probable cause, and that's a very low standard. And I set a bond of $100,000, which just stayed at that amount. And the bond of $150 is stayed on the possession of ammunition. And I did ROR the defendant on the DWLS.
Judge, the only argument I would have, would you consider reducing the bond? I know that,
I already denied that. I forgot to say it. I deny reducing the bond, and the bond stays at $100,000.
okay,
Your Honor, he does have an out on bond the state has not yet filed on.
I won't take any action since the state has not yet filed on it.
thank you for your courtesy, Your Honor.
All right, thank you both.
And thank you, Ms. Fleming, as well.
I am ordering the defendant to possess and consume no illegal narcotics and to possess no firearms and no weapons and no ammunition, and surrender any firearms or weapons or ammunition to law enforcement within 24 hours of release.
Yes, ma'am. Thank you again, Your Honor.
You're welcome.
Thank you, Madam Clerk, for your courtesy as well.
All right, what next? Oh, my turn to call cases? Why are they lopsided? Did I do that, or did you? Oh, okay. And you took care of it for me? All right, thank you. I forgot. Donald Ayers?
Your Honor, Ayers is currently on mental health status.
Would you like to waive or reset, Ms. Public Defender?
There's an offer reset for tomorrow, Your Honor.
All right, reset for 24 hours. He's on medical. Angel Tyrone Canales,
Canales is also on mental health status, Your Honor.
mental health status, waive or reset, ma'am?
Reset, Your Honor.
All right, reset for tomorrow. Defendant is on mental health status. Okay. All right, okay.
Oh, okay, okay. Okay, good.
Michael Fernandez,
Fernandez bonded, Your Honor.
previously bonded per the jail staff. Ada Figueroa. Ms. Figueroa, ma'am, I find probable cause in your case for possession of drug paraphernalia.
Your Honor, state is gonna announce a no info.
State is no information in that case. Ma'am, I am ordering you to be released based on the state's no information.
Thank you.
You're welcome, ma'am.
All right. God was with me.
All right. Franklin Ferguson,
Ferguson is currently on behavior status, Your Honor.
we'll reset him for tomorrow.
Yes, Your Honor. Yeah, just make a note. Because it was weird.
Val Reese, Devon Griffin. Mr. Griffin, in your case, I find probable cause for resisting an officer without violence. Bond stays at 500. And possession of paraphernalia, the court will set a bond of 100.
And Your Honor,
Yes, ma'am.
the state did convey an offer of an adjudication of guilt, credit time served, and court costs. And Mr. Griffin would like to accept and enter a plea of no contest.
All right.
And in exchange for the plea, Your Honor, I'd ask that you take no action on the out on bond.
Yes, ma'am.
Hold on, I'm sorry, I'm appointed. You're welcome.
Mr. Griffin, is this your signature here at the bottom of this plea form? Yes, ma'am. Did you read the plea form before you signed it? Are you under the influence of any alcohol, drugs, or medication? No, ma'am. Do you understand a conviction on your case will subject you to deportation if you are not a U.S. citizen? There is a sufficient factual basis as to count 1 and count 2. I will adjudicate you guilty. How much time served?
2 days.
Order 2 days in jail to run concurrent on both counts with credit for 2 days' time served. Further, you must pay all mandatory court costs associated with this charge within 180 days of your release. I am ordering your release as to this charge. You have the right to appeal the sentence if you wish to appeal. You must do so in writing within 30 days of today's date. I will take no action on the case in which you are currently out on bond. And do you have any questions, sir? No, ma'am. All right, thank you, sir. You may exit. Thank you. William Hamilton,
Hamilton bonded, Your Honor.
previously bonded per jail staff. Michael Rodriguez. Come for, oh, is that not Michael Rodriguez? Oh,
Case number, Your Honor, or booking number, sorry.
State, are you no infoing that one too?
Do you have the booking number so I can see?
Oh, do I have the booking number? Oh, yeah, I'm sure I do. But I don't see it, so I'm just let the clerk tell you where. Booking number, he's not here.
220-25950.
He was a co-defendant with Ada Figueroa,
I don't,
which was no info.
I don't have anything.
Can you give the state the case number? Do you not have it, Ms.
No,
Fleming?
Your Honor, I don't even have an affidavit for it.
I don't either, Your Honor.
So I'm the only one who has it? Miracle of miracles. I have it, you guys don't. Usually you have it and I can't find it
He hasn't,
anywhere, and I'm looking all over for it.
he was an add-on, and it said that he was supposed to be seen first session. Let me see.
Does he show on the docket for today?
The first session is showing first session, though.
First session? So,
Because he's an add-on, so he may show up on tomorrow.
are we able to find him somewhere in the jail and bring him over here?
Let me pull up, I'm pulling up first as well.
His arrest was 2008. Who's in the military? Who can tell me what time 2008 is? Well, he should be on that, he should be on today.
He didn't make our docket, Your Honor.
Oh, okay. Look at all y'all knowing military time. And me, I have to count my fingers, go back, and then I'm still wrong. So,
Michael Rodriguez?
He's in first session.
Yeah.
I don't know, I don't.
Can we get him over?
We saw him first session. He did have a misdemeanor charge for drug paraphernalia, but he bonded out on that charge. Then he
Oh.
did the add-on for the
Okay.
DV.
Well, I'll ROR him on this then. How about that? He's not here, but I'm gonna ROR him.
He already
Oh, he bonded.
bonded for the drug paraphernalia. So we seen him first session for his.
Oh, I saw him. He did see him. I eyeballed him. He was here.
For DV first session.
Okay, so he was physically here. I get it now. All right, so he was physically here and he already bonded on this case per the jail staff. I would have ROR'd him though. Okay, Jason William Scott. Reset or waive,
Waive, Your
madam?
Honor.
So his presence is waived due to medical reasons, and the court does find probable cause for trespass, and bond is set at $100. Antonio Maurice Atterbury. Mr. Atterbury, you were picked up for failing to appear. Bond will stay set in your case at $5,000.
Thank you, Your Honor.
You're welcome, sir. David Williams.
Your Honor, he's currently on behavior status.
All right, Mr. Williams, reset.
Yes, Your Honor.
Will reset for tomorrow, 24 hours, due to behavior. Dwayne Graham. Sir, you were picked up for failing to appear. Your bond stays at $500.
Your Honor, state did convey an offer to Mr. Graham
All right.
of an adjudication credit time served.
And he would like to accept it as a plea of no contest, Your Honor.
All right, are you able to stipulate to a factual basis to the DWLS charge?
Yes,
Mr. Graham, sir, is this your signature here at the bottom of his plea form?
Yes, ma'am.
Did you read this document before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medication? Do you understand a conviction on your case will subject you to being deported if you are not a U.S. citizen? And counsel is stipulated to a factual basis, and I find you to be alert and intelligent. Sir, I will adjudicate you guilty. How much time, sir? 2 days?
2 days.
Order 2 days in jail, credit for the 2 days you've served, and order you to pay mandatory court costs. All court costs must be paid within 180 days of release. Any questions? You have the right to appeal the sentence. If you wish to appeal, then you must do so in writing within 30 days of today's date. Thank you. Okay. Carson Holra. Previously bonded per staff. Cornell Moraine.
He refused his appearance, Your Honor.
Phil, waive, Ms. Public Defender?
Yes, Your
All right, the defendant was picked up for failure to appear. Bond stays at $500. His appearance is waived by counsel. Karina Angel. Ms. Angel, in your case, the court finds probable cause for throwing or shooting a projectile into an occupied structure or dwelling and driving a vehicle from which shots are fired. The court will order a bond stay at $3,500 on count 1 and $1,500 on count 2. The court's ordering no contact with the victims, possess no weapons, no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. No, and not to return to the location where this incident occurred. Michael David Backman. The court finds probable cause for burglary of an unoccupied dwelling while unarmed, and bond stays at $5,000. The court finds probable cause for petty theft or theft, bond stays at bonds is set to $100. The court's ordering no contact with the victim, no return, possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. The court revokes bond on your out on bond case and sets a bond of no bond.
Your Honor, would you consider revoking and doubling as opposed to holding him at no bond, being that he was cooperative with law enforcement?
What says the state?
Your Honor, state will leave it within your discretion. We did file the burglary and the trespass. State's main concern is he has a pretty lengthy theft history, including his last petty theft in July of this year. However, state will leave it within your discretion, Your Honor.
I'll go ahead on and grant the motion, and I will order that the bond be set to, well, I don't know what the breakdown is for count 1 and count 2.
We filed trespass on a designated construction site in F3 and burglary of an occupied structure in F2.
All right, I'll set a bond of the F2 is count 2?
Yes, Judge.
On count 2, I'll set a bond of $5,000. On count 1, I'll set a bond of $1,500. The original bond is revoked. That's a little more than double, but he does have a bond. And the conditions of that new bond are no return, no contact with the victims. Thank you. Morris Baker, in your case, the court does find probable cause as follows. Count 1, armed burglary of a dwelling with a firearm, bond stays at no bond. Criminal mischief, bond is set to $100. Grand theft, bond is set to $100. Possession of a firearm by a convicted felon, bond is stayed at $5,000. Possession of cocaine, bond is set to $100. Possession of cannabis with intent to distribute, bond is set to $100. On the out on bond matter, the court revokes the bond and sets a bond of no bond.
Your Honor, just to cater to the court, state has not yet filed on that out on bond.
Oh, the court is going to rescind that order and instead take no action on the out on bond case.
Your Honor, state would just ask for no contact, no return.
Yes, ma'am. The court is ordering no contact, no return, possess no weapons, possess no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. Christian Bradley,
Bonded, Your Honor.
previously bonded per the jail staff. Jonathan Carrillo. Oh, this is one that I didn't have. I didn't have it. And I still don't. Rahib Shawbury. I need the charging affidavit. It wasn't attached. Ms. Fleming, do you have charging, do you have the affidavit on the Jonathan Carrillo case?
I do not have the factual basis, no, Your Honor. I just have
Nobody has it.
instantaneous.
I don't. The court does not have it. The state does not have it. The clerk does not have it. What says the counsel? You're here
Ask
on
that he
this?
be released on his own recognizance, Judge.
Your Honor, state would object. There has been a warrant, so PC has already been bound.
But this is initial appearance and I have to set bonds and I cannot because I don't have any frame of reference. Do you want 24 hours?
Yes, Your Honor. I have a note in our system. I don't know what it's from 10/28, no bond in all 3 counts.
What is this? Sorry, slow down a little bit.
But it says no bond on all three counts. Defense Harold Thompson asked for reasonable bond. Judge set no bond on all three out of Orange County.
Does it say whether that was a court hearing or was it the, when the, the officer walks the warrant through to the judge?
I'm not sure, Your Honor.
Because I see where, it looks like the officer walked the warrants through and the judge did set no bond on 4 counts, but there is no affidavit attached, so I can't go back and evaluate what the bonds should be because I have nothing.
Understood, Your Honor. State would ask for 24 hours.
All right,
Judge, I would object to the 24 hours. I would submit that the state had 7, 8 days because he was picked up on this in Kissimmee. He's been there for over a week and just got transported here yesterday. So they've had more than 24 hours.
what? Oh, okay. How long will it take? A few minutes? All right, it looks like we may be able to request the warrants to unit to provide us with the affidavit. And if they can provide us with the affidavit, then I may be able to address bond and address probable cause as well. Each one of these charges are charges where the court would ordinarily set a bond. So I just need to see some,
Yes, Your Honor.
the warrant.
He is entitled to a bond on all of them.
Yes,
1, 2, and 4 are all F1s. 3 is an F2.
Okay, thank you. All right, we don't have it yet. If he can, deputies, can you all, we'll pass him? And, counsel, you want to just have a seat? Okay, thank you. Rahib Chowdhury. That's fine. There, okay, this is the second one. I don't have this one either. No.
Your Honor, state did file an information on this one. I have the,
What counts did you
document.
file?
we filed the ag assault on Leo with a deadly weapon, the F3, and the attempted carjacking, the F2.
Okay, all right. No, the state filed the information already. All right, sir, you're charged with count 1, aggravated assault on a law enforcement officer with a deadly weapon, and count 2, attempted carjacking. State any recommended bond as to these counts?
Your Honor, Mr. Chowdhury has very limited criminal history. However, I'm unsure regarding his community ties, as he told PTR he does not know. However, they're both serious charges, one being an F3, one being an F2,
Yes.
and violent charges. So state would ask for at least 10 on the F2 and at least 5 on the F3.
Does the defense wish to be heard on the bond?
I'm sorry, what was the bond amount you recommended?
She's asking for 15,000 minimum total, 10 on the F2 and 5 on the F1 minimum. She's asking the court to consider the nature of the offense.
No objection, Your Honor.
Oh, no, well, the court will grant the state's request. A bond is set at $5,000 on count 1 and $10,000 on count 2.
I'm sorry, he stated, okay, he's asking. Listen, you have to give me a chance, I need you to be clear. Your Honor, based on his history, I would ask for 5,000 on count 1 and 5,000 on count 2. He has no criminal history. He stated he's lived in Orlando area for over 15 years. His family resides here. So I would ask.
Let me ask the state for more clarification. You said that he has no priors or very limited priors?
From what I see I believe he just has prior arrests, the petty theft and the resisting. State's main concern is the allegations within the affidavit. They include multiple victims, they include chainsaws, they include pulling people out of their vehicle. It was incredibly violent. State's concerned regarding the victim's safety.
A chainsaw?
Yeah, sure.
Well, listen, I'm gonna, the state's recommendation, of course, is, well, that's well taken. I was gonna stay at 5,000 on count one and 10,000 on count two. Possess no weapons, possess no firearms, surrender any weapons or firearms to law enforcement within 24 hours of release, and have no contact with the victims.
Your Honor, State would also ask for a no return.
No return to the scene where this incident occurred. Yes, ma'am.
Your Honor, this happens frequently. Whenever the officer walks it through and it doesn't get uploaded to the clerk's office in the however amount of time, State often usually calls the warrants unit, and then we try to call the actual deputy or officer that's on it. Usually warrants unit does not have it, and then they usually send us to the records unit. They usually do not have it either. So usually will get uploaded to the clerk's office within 24 hours after they're seen at IA, or we can usually get it from that particular officer deputy. But the warrants unit or records generally do not have it.
Are you,
Process of how it goes.
okay, are you saying that if I gave you 24 hours, you feel pretty confident you all can get it?
In my experience, we've been able to, Your Honor, yes.
All right, I'm just gonna grant the motion for a 24-hour. I understand that you said the defendant was arrested in Seminole or Osceola County? Oh, I'm sorry. Yeah, that's fine. We're gonna recall Jonathan Carrillo. All right, as to Mr. Carrillo, the state does not have the additional information, and the clerk has been unable to locate the warrant. I'm going to give the state 24 hours. State, you feel pretty confident you'll be able to get the warrant? I'm sorry. Yes, you'll be able to get the warrant within the 24 hours.
We are usually able to track it down within 24 hours, Your Honor, yes.
All right, so I'm going to reset the case for 24 hours. I'm granting the state's motion.
What time will that be tomorrow, Judge?
Madam Clerk, will that be in the morning? Okay. Sir, they start at around 11, and you can always contact the clerk to find out whether they will put your case up towards the front of the docket.
Okay.
There we go. Yes, put on the court minutes, attorney wants to be notified and to be present. All right. Willina Chooks. Hi, Ms. Chooks, ma'am, in your cases, the court finds probable cause for possession of cocaine. Bond stays at $1,000. For possession of paraphernalia, the court sets a bond to $100.
Excuse me, can you, I'm sorry, ma'am. I can't hardly hear out of one of my ears. Can you say them bonds again, please?
Yes, the bond for the possession of cocaine is $1,000,
Okay,
and for the possession of paraphernalia is $100.
okay, and then what else?
The driving while license suspended, the bond stays at $250.
Okay. Ma'am, that's a, that's a civil matter right there.
I already talked to you about that.
It's charged as a criminal matter, ma'am.
Yes, ma'am. So do I, will I ever be able to get my license back because somebody else got the people that's civil suing me?
Ma'am, I'll have to refer you to your lawyer for legal advice. I am not able to give you legal advice on recovering a valid driver's license.
Okay, well, thank you.
All right, thank you, ma'am.
All right. You have a great day.
You too, ma'am. Elvisius Decima,
Your Honor, he bonded.
previously bonded per the staff. Tyler DeVoe.
He qualifies for pretrial.
All right, Mr. DeVoe, in your case, the court finds probable cause for possession of cocaine, and I am ordering you to be released on the pretrial release program, ordering you to possess no illegal narcotics as a condition of release. Thank you, sir. Michael Dyson. Mr. Dyson, you were picked up for failure to appear on 3 counts. Bond stays at no bond on each of 3 counts. Thank you, sir. Willie James Evans Jr. Mr. Evans,
Yes.
you're charged with burglary of a structure. The court finds probable cause. Bond stays at $3,500.
Actually, on this,
I'm sorry.
on this case, I did have a PC challenge.
Oh, go ahead.
As to the burglary of a structure, based on the arrest affidavit, there is no crime within. It appears that he was merely sleeping. So I would argue no PC as to the burglary and ask that you find PC for a trespass.
Because there was no crime within?
Yes, Your Honor, in order to have a burglary,
Well, wasn't him sleeping on the property, wasn't that a trespass?
it has to be other than a trespass.
Ms. Fleming, shall I grant her motion or deny it?
Your Honor, as to Mr. Evans, state would ask that you find a trespass. Arguably, he remained in the building stealthily, which could be one of the reasons to point towards a burglary. However, at this time, state has no objection to finding.
I'm gonna grant the motion, and I'll find probable cause for a simple trespass.
And Madam Clerk, that case number, or that, oh man, my system just went down, I'll give you the,
And I'll set a bond of $250 as to the trespass.
and Your Honor, state would ask for no return, no contact with the victim, no contact with the co-defendant.
The court grants that and orders no return, no contact with the co-defendant, and no contact with the victim. Larry Graham. All right, sir, the court finds probable cause for grand theft and dealing in stolen property. As to the grand theft, bond stays at $150, and as to the dealing in stolen property, bond stays at it's $2,500. Thank you. Oh, sorry, one moment, but let's bring him back. Let me see here, I must have missed that.
Madam Clerk, it's 81008
81008.
for the trespass on no structure.
The court's ordering you to have no contact with the victim. Thank you. Gregory Harris. Third, the court finds probable cause for possession of cocaine, and bond stays at $1,000. Thank you. Ramon Harris.
Harris refused his appearance, Your Honor.
I will waive, Your Honor.
Okay, if you, I am gonna revoke his bond on his other case if it was filed.
It
and
was.
said- It was, or it was not?
No, it was not, Your Honor.
Okay, then, all right, that's fine. Then the defense has waived his appearance. The court finds probable cause, and bond is set, stay at $1,000. And state, you agree you haven't filed on the other case?
Yes, Your Honor.
Okay, no action then on the out on bond matter. Zarin Jackson. All right, Mr. Jackson, the court finds probable cause in your case for fleeing and attempting to elude a police officer. Bond is set to $4,500. Thank you. Jeremiah Joseph. The court finds probable cause, well, actually, you were picked up for failure to appear, and bond will stay at no bond. Leonard Keaton. Okay. All right, Mr. Keaton, in your case, the court finds probable cause for possession of 3,4-methylene methamphetamine MDMA ecstasy. Bond stays set in your case at $1,000. Thank you, sir. All right, Mr. James Leon.
Good morning, Your Honor.
Good afternoon. The court finds probable cause in your case. Actually, you were picked up for failure to appear, sir, for 2 counts. Bond stays at no bond on both counts. And Linda Lewis?
Yes, ma'am.
The court finds probable cause for grand theft, 3rd degree of a motor vehicle, and bond stays to $1,500, ma'am.
Ma'am, may I say something? I'm the one that called on this gentleman. He lied on me, the police let me go. I don't even live here anymore. I left because of this gentleman. The address where I didn't know nothing about no court case or nothing. My address is a St. Cloud address.
Well, thank you.
I thought it was done and over with. Excuse me, lady.
You're not here for a failure to appear.
I mean, I didn't have a no, and I don't live there. I live in St. Cloud. I don't live here.
You're here for grand
I
theft.
came back to visit. How you gonna charge me with theft when I got the keys? He gave me the keys. The neighbor even told me he gave me the keys.
I mean, it's up to the judge. Grab your paper. Go ahead. You good.
Sorry, ma'am. I have James Mitchell. All right. The court finds probable cause for possession of 3,4-methylene methamphetamine MDMA ecstasy, and bond stays at $1,000. Thank you. Christelle Myrtle. In your case, the court finds probable cause for possession of cocaine, and bond stays at $1,000. Thank you, ma'am. Samuel Parham. The court finds, actually, you were picked up for violation of your conditions of pretrial release, and bond stays at no bond, and failure to appear on a felony warrant, and bond stays at no bond, both cases. I appointed the public defender, so let the public defender advise. Iago Rodriguez. Iago Rodriguez.
Your Honor, the next on our roster is Robert Rouse.
Robert Rouse.
Just possession.
All right, the court finds probable cause for count 1, larceny or theft. And bond stays at $2,500. Count 2, possession of cocaine, bond is set to $150. Count 3, possession of paraphernalia, bond is set to $100. You're ordered to have no contact with the victim and no return to the scene. Okay. Robinson Ruiz. Bonded per staff. Shondo Sharkey. Yes, ma'am. All right, the court, you were picked up for failure to appear. Bond stays at $300 on count 1 and $2,000 on count 2. Thank you. Wendell Sowles, Leslie Wendell.
Souls is currently on mental health status, Your Honor.
Mental health status,
The attorney. Yeah, because.
waive or reset, Ms. Public
No, Your
Defender?
Honor, I will waive, and the only, I had a PCS to the possession with intent. I would just argue there's no PC for intent to sell and ask that you only find PC for possession of the
Are we
MDMA.
talking about Souls?
Yes, Your Honor.
Okay. Souls wasn't charged with possession with intent.
Count 2.
Count 2 was possession of MDMA with intent.
I show count 2 as possession of MDMA. I don't show
I
any.
believe the charge name got cut off, just because the drug name is long.
All right, let me look at it again.
Okay.
I don't see probable cause for intent to sell state.
Your Honor, state agrees.
Oh, okay. Your motion's granted.
Thank you, Your Honor.
The court, as to count 1, finds PC, probable cause for possession of fentanyl. Bond is set to $1,000 instead of $2,000. I reduced the bond. Count 2, possession of 3,4-methamphetamine, MDMA ecstasy. The court finds probable cause for that charge, but the court does not find probable cause for with intent to sell, and bond is set to $150. Possession of paraphernalia, bond is set at $100. Resisting an officer without violence, bond is set at $100.
And Your Honor, or Madam Clerk, just for the record, the possession of the MDMA ecstasy will be 893.13, sub 6, sub A.
Thank you, Ms. Fleming. Yes, ma'am. Yes, ma'am. Thank you. Warren Sweat. All right, Mr. Sweat, the court finds probable cause for possession of 3,4-methylene methamphetamine MDMA ecstasy, and bond stays at $1,000. Account 2, possession of cocaine. Bond is set to $150. You have 3 out on bond cases, 1 for possession of cocaine. Case number 2022 CF 113030AO has the state file charges.
Your Honor, my case management system went down.
No, Your Honor.
You have it?
No action on that case. The court takes no action on the alcoholic beverage possession. In the possession of meth, 2022 CF 8419AO has the state file charges.
No, Your Honor.
All right, no, there's no action on that either.
I can't get in.
Here you go.
Taylor, Ashler, Taylor. Mr. Taylor, the court finds probable cause for count 1, fleeing and attempting to elude an officer. Bond is set to $4,500. Count 2, possession of cannabis greater than 20 grams, and bond is set to $150. Count 3, resisting an officer without violence, and bond is set to $100. If the out on bond matter has been filed on, the court is revoking and setting no bond.
It has not, Your Honor.
Can we check that, Madam Clerk? 2022 CF 6231AO.
I believe you.
Okay.
Yeah, thank you, though.
All right, the court will take no action on the out on bond matter. Mario Taylor.
Your Honor, he qualifies for pretrial.
Mr. Taylor, the court finds probable cause for driving on a suspended license as a habitual offender. Even though he qualifies for pretrial, the court will prefer to set a bond in this case. And bond will stay set at $2,500. You are ordered to not drive a motor vehicle as a condition of bond.
Your Honor, he can't afford the $2,500 bond. I would ask for a pretrial release, given that he qualifies. If he violates, he could be brought back here and held at no bond.
It's the nature of the charge. It's a habitual traffic offender, so you cannot become a habitual unless you have the same charge twice before.
Your Honor, I believe he has 4 prior convictions as a HTO.
That motion will be denied at this time.
Thank you.
Jose Torna. Mr. Torna?
Ma'am?
The court finds probable cause in your case for larceny, theft, and bond stays at $1,000. You're ordered to have no contact with the victim and no return.
Do I have an affidavit?
Thank you, sir. All right, Madam State, this is the case where I wanted the state to,
Sorry.
Yes, Your Honor, I did look back over it.
Yes.
Usually when we see these, there were like 14 bullets in the gun and then 1 in the chamber.
Yes.
However, that's not the factual basis that we have in this case.
right,
So in that regard, state would ask that you find PC as to count 5,
okay.
and then ROR as to 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, and 18. And state would ask for a 24-hour reset. But so 6 to 18.
Okay,
And then state would argue that there's PC for 1 count of it, the possession of the firearm ammo, because there was allegedly that firearm.
you still want the 24-hour reset even with the concession that you just made?
Yes, Judge.
Okay. All right. Well, I'll just reset the case for 24 hours for the state to supplement you're asking me not to release him.
Your Honor,
Right.
state has no objection to you setting bonds on 1 through 5 and then on 19.
19.
So he can bond in the interim if he would like to.
But you're asking me for the 24-hour reset. So what happens on the ROR, if I ROR him?
If you
Am I
ROR
holding
him
him from being able to be ROR'd on those cases if I give you a 24-hour reset?
Well, he can either bond on the additional charges in the meantime, or if he does not bond and we get an affidavit tomorrow, then bonds will be set on those charges if PC.
Right. But he would be stuck in jail regardless, right?
No, ma'am.
No.
Okay.
Because of the ROR, Your Honor, he'll be able to get out if
So
he can
the
post.
case will be called, but the defendant can potentially not be here
He potentially can bond before.
Oh, okay.
The
So
reset
you're not
treatment.
asking me to hold him.
No, ma'am.
You're just asking me to give you 24 hours.
To get an additional affidavit, and if he's here, we'll address it. If he's not, then he already
I
bonded.
understand. All right, as long as you're not asking me to hold him,
No, ma'am.
then I will grant that. And the court does find probable cause as to count 1, grand theft, 3rd degree of a motor vehicle, and the court sets a bond of $150. Count 2, possession of a firearm by a convicted felon. Bond is stayed at $4,000. Count 3, carrying a concealed firearm. Bond is set to $150. Count 4, possession of a firearm by commission of a felony. Bond is set to $150. Count 5, possession of a firearm or ammunition by a convicted felon, and bond is set at to $150. And count 19, grand theft third degree of a firearm, bond is set to $150. As to counts number 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, and 18, the court is allowing the state 24 hours to supplement, and the court orders a release on recognizance as to each one of those counts.
And Your Honor, the only conditions it would ask for no return, no contact, and no weapons.
The court grants that and orders no return to the scene, no contact with the victims, possess no firearms or no weapons, and surrender any firearms or weapons to law enforcement within 24 hours of release.
That's it.
Thank you, Madam Clerk. Anything else? Anything else from anyone else? Court will stand in recess if no.
Nothing from the state, Your Honor.
Nothing from the bench, Your Honor.
Recess.